Ready? Start. We have carefully considered the submissions of both the sides and perused the material on record. Stop. In our opinion, the claim of the assessee has been properly and validly negatived by the revenue authorities. Stop. In the first instance, this guarantee was given before the start of the work by the assessee and could therefore be held to be capital in nature. Stop. Secondly, this was not an expenditure which had been ascertained and which had crystallized. Stop. It is true that the release or refund of this amount depended upon the satisfactory performance by the assessee, who is the contractor's. Stop. This, however, does not mean that there has been, as a matter of fact, any unsatisfactory performance on the part of the assessee, or that the assessee is certainly going to get this amount forfeited. Stop. Both possibilities are inherent in the situation. Stop. We therefore do not accept the proposition that there is the expenditure, for the expenditure is an outgoing. Stop. Expenditure connotes any sum going out finally and permanently from the coffers of the assessee. Stop. Though the bank guarantee has been given, the amount cannot be considered as having gone out of the hands of the assessee irretrievably and cannot therefore be considered as an item of deduction even under section 28 of the Act. Stop. We therefore hold that this item, along with three earlier items discussed above, have been correctly disallowed as a deduction by the revenue authorities. Stop. This ground is therefore rejected. Stop. The facts of the case for the assessment year under reference are similar to the facts of the case for the assessment year 1985-86. Therefore, respectfully following the aforesaid order of the tribunal, we hold that the appeal was justified in sustaining the disallowance of the aforesaid amounts. Stop. We confirm his orders and dismiss this common ground of appeals for both the assessment years under reference. Stop. The next ground of appeal for the assessment year 1989-90 relates to the fact that the appeal was not justified in sustaining disallowance of rupees 1 lakh under section 40A within bracket 3 of the Income Tax Act. Stop. The facts of the case are that while completing the assessment for the assessment year under reference, the assessing officer observed that the assessee had made cash payments exceeding rupees 10,000 in violation of provisions of section 40A within bracket 3. Stop. The assessee explained that such payments had to be made because the parties from whom the assessee made these purchases insisted on cash payments, and therefore there were exceptional circumstances justifying such cash payments. Stop. However, the assessing officer observed that the assessee did not produce any letter or evidence to substantiate its contention that such payments had been made on insistence of the parties. Stop. This ground of appeal is allowed. Stop.